Okay, in this final video, we're just going to zip through this real quick, point out the key features. And again, if you like this content, if you want full access to the templates and even access to myself, I do coaching sessions, but also the members can hit me up in the THC group. Many hours, at least 5 hours a day, I'm in there. You know what I'm saying? I'm in there in silent, but you can send me a message on Telegram. To get access to that, you have to have membership on the site. So yearly membership is $224 or $225, something like that, or $32 per month. So today, again, this is the final video I'm going to do on this subject. We're talking about the equitable lien, right? We already talked about 15 USC as a tracer flag, letting them know that this is a security interest or a speculation account that we're creating. Basically, this is a charge and it creates an account, which is in part it's a contract, and then in this commercial quote-unquote system it constitutes money. This could be a taxable event, and these are just ideas I'm throwing out there because this gives you further insight into how to enforce your equitable claim of lien, which is what we have here. This particular, so we have it set up here. This is the lien claimant, also known as the lienor, and this is the lien debtor, also known as the lienee. And you can look these terms up. The surety bond is the personal property subject to this claim of lien. It's the personal property of the lien debtor, which is the public officer. We do this in the form of an affidavit, right? Because so now to give them their due process, they can respond in like form. They can respond in an affidavit to rebut or whatever. The other thing about this lien is this is the last step. So once you sign or once you execute this instrument, it is done. You can give them notice. You should give them notice that the lien has been recorded. There's no more due process to be had. But I like to think that even though you've done a full administrative procedure and you've got defaults that led you up to this point, anything can always be challenged and corrected. So this is why, more than just a notice of lien, we have an affidavit of lien spelling out the facts that spelling out the facts related to the lien, so that at any time, anyone who doesn't like this or thinks you're damaging that person or their agent, attorney, or who their boys are, whoever, they can get at you with an affidavit. The problem with these affidavits, and this is what I want you to think about when we read through it. I want you to think, if you were the person and I was writing this affidavit, how would you rebut it, right? The reason why he's unable to rebut my affidavit is because I keep it factual. Everything I state in the affidavit can be verified. Same has to be with your affidavit. You can't make accusations that you can't prove. You can't make accusations based off of how you feel about something, because someone else may look at the situation and not feel the same way. So I was very careful when we created this administrative procedure. We had to work our way backwards, right? We thought about the remedy that we wanted, the facts, the things that needed to occur to get there, and we really clarified our administrative procedure so that the default provisions of it, or when the person or when they go through our administrative process, we have evidence of all the facts that's necessary to get to the point we are today. So let me go ahead and read it. But the key is it's an affidavit, and we express in here no other form of response would be acceptable other than the affidavit. That's almost like it's like a real nice checkmate. This affidavit is a legal expression of my right to petition the government for redress and is protected under the First Amendment of the United States Constitution. Any third party who attempts to cancel, remove, mutilate, obliterate, or nullify this affidavit in any way must provide an affidavit of their own, sworn or affirmed under penalty of perjury, to rebut and support their claim. Said third party's affidavit shall express their lawful basis and authority for making their counterclaim or other determination. Failure to respond in accord with these requirements will result in said third party being added to this claim as a lien debtor. Nobody wants that, right? Nobody wants that, because we're going after surety bonds. And again, I'm sure you already know, but if you don't know, the surety bond is critical because you cannot go to work without having that surety bond in place, and you cannot replace, if there's a claim on a surety bond, that claim has to come to a conclusion. It either has to be settled, it has to be rejected so further process can take place. But I'm very interested to see if people end up doing these things, what things are going to look like. Because I can only, I haven't seen this all the way to the other end because I don't have any situations going on. But I can only look at this like a car dealership, right? Car dealerships have to have a surety bond in a certain amount, sometimes like $50,000 or something like that. And what this means is, in order to sell any cars in that state, that bond has to be active. If somebody goes and puts a claim on that bond because they've been cheated or something crazy occurs, the dealership must settle that very quick, because if they don't settle it quickly, it can cause them to have to shut down, right? It can cause them to have to shut down and not be able to do business because they don't have the proper bonding and licensing to do the business, right? So you see how important this is? All right. Here's the account. I, John Doe, trustee for the John Alex Doe Trust, hereinafter affiant, being first duly sworn, depose and say that. Here's something to interest. If anybody has some information on this, get back with me. Typically, when you do an affidavit, you're speaking on your own behalf, but they tell you that a trust is a legal person, right? It has all the rights of a natural person. So I asked the question, I haven't seen any authoritative answer. Can I make an affidavit in my own name on behalf of the trust? I believe you can, right? And the reason why I did this is because, one, we just spoke about the power of the affidavit, but also I'm expressing that a trust exists because this is an equitable lien. So when you're dealing with equity, I believe it is important to make sure that there's evidence that your property is titled in trust. We talked about that in some other videos too, when I was talking about bringing the certification of trust. That was already a part of the process that led up to here, so I don't have to provide a certification of trust with this. And I'm just going to read through this, and like I said, every line that I think is significant, that I want to break it down and tell you why we came to this conclusion, what research we did, etc. So I, John Doe, trustee for the John Alex Doe Trust, being duly sworn, depose and say that I, being over the age of 18 years, and competent to testify to the matter set forth in this affidavit, I do hereby declare that I am duly authorized to make this claim in my own name and on behalf of the trust. I am the lienor, also referred to as the lien claimant, and I am asserting my claim against the lienee, also referred to as the lien debtor, Diane Schroeder of 49 Rancocas Road, and I give her address, under surety bond number 1234567. My claim is based on breach of fiduciary duty, non-acceptance of payment, dishonor, and default of performance based on the Constitution of the United States, the laws of the United States, and the fiduciary appointment and authorization letter delivered to the lien debtor on September 21st, 2022 at 11:06 a.m. I am claiming an equitable lien exclusive to the jurisdiction of Article 3 of the Constitution of the United States of America, which extends judicial power to all cases in law and equity. Attached to this affidavit as enclosure 2 is the security agreement, which includes a true copy of the document titled Fiduciary Appointment and Authorization Contract with an express acceptance of the lien debtor's oath. And if you're following along, when I say, attached to this affidavit as enclosure 2 is the security agreement, I put in parentheses UCC 9-10274. So they know where I'm going with this, right? Because I'm telling you, I'm showing them by putting these UCC codes in parentheses throughout this whole thing that I have lined this claim on your surety bond up with my security agreement and my enforceable interest in collateral based on having such contract and what the Uniform Commercial Code says, right? So I'm just lining this up so that they can bounce this off of, what I'm stating, they can bounce it off of the UCC, right? So I'm showing them the legitimacy of my claim and why it's attached and enforceable in the collateral. And at the same time, remember, this is an affidavit. So if any of these statements are untrue, they must be rebutted in the form of an affidavit. If somebody tries to stand in the way, right, they can be added to this as a lien claimant. As a lien debtor means you can then send the same letters that we sent, get their surety bond information, and put another claim on that. And not only one person can do this, everybody listening to this can do this if they had a proper claim. All right. So where are we at here? We're at about paragraph 6. I am claiming an equitable lien exclusive. Okay, we already read that. And we said attached to this affidavit is enclosure 2 is the security agreement, and which is the fiduciary appointment and authorization contract with an expressed acceptance of the lien debtor's oath. Because in that fiduciary appointment and authorization contract, there's a section that says acceptance of oath and performance guarantee. And in that is where we expressly accepted the oath. Also, if you have access to the website, we have the letters in there. You can actually request the oath of office. They can send it to you, the states that will send it to you. And when they do, it does have a signature on it. You can get a certified copy of that record and put your physical acceptance on top of it. But that's not necessary, because an express acceptance, the way we're doing it, is also sufficient, right? And that's also mentioned in the Uniform Commercial Code, and it's referenced in this affidavit. The above referenced documents constitute the contract from which this lien arises. The contract was delivered to the lien debtor for performance by service through United States Postal Service under registered mail article number R123, etc. And receipt of the contract is evidenced by enclosure 3, USPS 3811, right? So all I'm doing is saying this was the contract. Here's the proof of the receipt of the contract, which is USPS 3811. That's the green card that you got back in the mail. And then I'm putting the Uniform Commercial Code in there, UCC 1-201B15. I'm not off my head. I can't remember what it means, but let's just look it up real quick. Let me go ahead and put that in here. If it'll come up. Oh, it's not going to come up. So let's skip that. We're not going to look it up right now. You can go back and look up these Uniform Commercial Codes. And you should. You should look up everything in here. Don't use it. Don't rely on the fact that I did it right, because I do make mistakes and I be working this stuff out. I have this, this template in my mind, and I start doing the research and working through it, and I work fast and I do make mistakes. You should fact check all of this before you use it, because I fact check templates and things before I use them, and sometimes the information stated is just dead wrong. All right, but that's not the case, but do fact check this and look over it. Okay, so where else are we at with this? Let's see. My claim of lien covers a security interest in the lien debtor's oath as collateral, which is expressed in the contract under the section titled Acceptance of Oath and Performance Guarantee, in order to ensure that the fiduciary, the lien debtor, would not derogate from the laws of the United States of America and fulfill the obligations of the contract. My claim of lien also covers a security interest in surety bond 12345 to recover agreed charges in accordance with the terms of the contract under the section titled Liability of the Fiduciary and the default provisions thereto, wherein the fiduciary accepts personal liability of up to 10 times the face value of the instruments. According to the terms of the contract under the section titled Acceptance and Refusal, any refusal or dishonor required an affidavit swearing or affirming under penalty of perjury that the fiduciary did not have the capacity, authority, obligation, or duty to perform under said contract. The lien debtor has failed to respond to the contract and has accepted the default provisions of not responding. The doctrine of good faith requires a fiduciary to act honestly and not mislead or withhold critical information, and the lien debtor has breached their fiduciary duty to account and provide accurate information. Furthermore, the lien debtor has also breached the fiduciary duty to release the security interest on the mortgage. The lien debtor has abused their authority by relying on color of law to deny my right to discharge the debt and redeem my property. I assert my right to file a financing statement to secure an amount authorized and agreed to under the terms of the original contract. I hereby assert my claim to recover damages in the amount of, insert your dollar amount there, $10 million, excuse me, from the lien debtor, Diane Schroeder, due to her breach of fiduciary duty, non-acceptance of payment, dishonor, and default of performance as described in this affidavit. I hereby declare under the penalty of perjury under the laws of the United States of America that the foregoing is true and correct. And again, as you see, this is after the administrative process has already taken place. So also, this affidavit, now what would you do with this affidavit after you execute it, right? Well, there's a couple of things you can do with it. Let's see. One, I would say one thing you can do is you can file a UCC. Or in some states, do your research on this. In some states, you can simply file this affidavit as a UCC, as a UCC financing statement, right? What's happening? You're financing the speculation account that you created. Remember, this Title 15 is a security. So some states, I have one in mind particularly, and what I'm saying is you can literally go file this affidavit as a UCC1 financing statement, and you don't have to do the UCC1 form. The majority of states are going to require you to do a UCC1 form. But what I'm stating is the UCC1 is a notice of claim and a security interest, and that is what this is. It has the same elements. Your creditor would be the lien creditor or the lienor. The debtor would be the lienee or the lien debtor. The collateral would be the surety bond, and that's it. That's really it. Surety bond, a claim for a certain amount in the surety bond. But the collateral is really under, I think, is box 4 on the UCC. The collateral would be the surety bond, and you could execute this affidavit. You can file a UCC1 financing statement that relates to this affidavit by filling it out kind of just the same way we just discussed it. And of course, none of this is legal advice. These are ideas and concepts and things, right? So in addition to doing the UCC1, if you really felt you needed to, you could attach this affidavit by uploading it through the portal and maybe doing a UCC3 if they don't let you upload the contract with the original UCC1 filing. Or you can mail it in. Or you can go down to your county and say, hey, can I record a lien against personal property in this county? And if they say, oh yeah, well, it's something we can do, then you can say, boom, here's my affidavit of lien, right? But once you execute this, you may want to record it or put it on record a plethora of different places. But more importantly, if you really have a claim, you have to call the person who holds the surety bond, the surety, which in this example or this idea and concept, it'd be Selective Insurance Company of America or whatever, right? So you would call them and tell them that you have a claim, and you wouldn't, and then you would ask, or you wouldn't call, you would call them, tell them you have a claim. You would do your research in that state to find out what are they required to do when they receive this claim, so you could know. Because I had to know that information before, because they wouldn't give you the information. So I had called 48 hours later asking for a claim number because I knew that they had to have one, and they provided it. So that's what you would do, because if you got into a car accident, you called the insurance company to settle the claim. I don't know how they're going to settle it. I don't know if they are going to. They could say, hey, nope, we don't see no damages here. You got to pay. At least now you can move your process on. Now you can sue. You can sue under this lien. And we might have to do that. And I don't want you to be discouraged about it, because we're going to take this lien in a court of equity. If we file a UCC financing statement on this equitable lien and we record it in the county and we don't get the results that we're looking for, then we can file an action to foreclose or to execute on this lien. And I actually look forward to the day when somebody does it. Why? Because we expressed it in the form of an affidavit. This is evidence. It has not been responded to. So the same problems that it presents now, it's going to still be the same problems if you sue right? If you sue or you do some type of action against the bond and the guarantor in court, and imagine while you're doing all of this, remember that surety bond, how much pressure can it take? Can that person keep going to work? So this isn't some lightweight stuff. I hope you enjoyed this. Let's discuss it more. Create your membership on www.thctrust.org. And, I hope you enjoyed the video. And again, all the templates of everything I discuss are available. They're all available. And one last thing I want to say, mentioned in the last video, but I want to mention it in this one again before we get out of here. This whole thing has been set up based off of an acceptance of an oath. That's not the only way to set up the contract, but I believe to have something enforceable, you want to make it clear that there's a fiduciary relationship and there's a record that there's a fiduciary relationship, so that then you can have a security interest in some collateral and expect performance under your contracts. Anyways, I don't want to misrepresent. These are just ideas and concepts that I'm studying. I've created templates, have a lot of information and knowledge on these things. Fortunately, I don't have these issues to deal with right now, so I'm not stating to you that I'm 100% sure that this is going to work like this, but I have a bunch of faith and confidence in the research. So peace and love. Thank you for your time. Thank you for your continued support, members, family, people of THCtrust.org.